Greetings and a very pleasant morning to everyone present here for the Regional Consultation on Effective Implementation of Juvenile Justice, Care and Protection of Children Act 2015, organized by the Department of Women and Child Development, Government of Odisha, and the United Nations Children's Fund under the aegis of High Court of Orissa at the Odisha Judicial Academy, Cuttack. We are honored to have amongst us Honorable Shri Justice S.Ravindra Bhat, Judge, Supreme Court of India, and Chairperson, Juvenile Justice Committee, Supreme Court of India, Dr. Justice S.Muralidhar, the Honorable Chief Justice, High Court of Orissa, Honorable Shri Justice Madan B. Lokur, former Judge, Supreme Court of India, and former Chairperson, Juvenile Justice Committee, Supreme Court of India, who has kindly consented to join us through virtual mode. Honorable Shri Justice Harish Tandon, Judge, High Court of Calcutta, and Chairperson, Juvenile Justice Committee, High Court of Calcutta. Honorable Shri Justice Debabrata Das, Judge, High Court of Orissa, and Chairperson, Juvenile Justice Committee, High Court of Orissa. Honorable Shri Justice Ashutosh Kumar, Judge, High Court of Patna, and Chairperson, Juvenile Justice Committee, High Court of Patna. Honorable Dr. Justice S.N. Pathak, Judge, High Court of Jharkhand, and Chairperson, Juvenile Justice Committee, High Court of Jharkhand. Honorable Shri Justice Parth Pratim Sahu, Judge, High Court of Chhattisgarh, and Chairperson, Juvenile Justice Committee, High Court of Chhattisgarh. Honorable Ms. Justice Savitri Ratho, Judge, High Court of Orissa, and Member, Juvenile Justice Committee, High Court of Orissa. Honorable Shri Justice A.K. Mahapatra, Judge, High Court of Orissa, and Member, Juvenile Justice Committee, High Court of Orissa. And all the Honorable Judges of High Court of Orissa, both present here and joined through virtual mode. The esteemed Advocate General, State of Odisha, Shri Bhaskar Sharma, Commissioner cum Secretary, Department of Women and Child Development, Government of Odisha, Shri Aravind Agarwal, Director, Odisha State Child Protection Society, Government of Odisha, Dr. Monica Nielsen, Chief of Field Office, UNICEF Odisha, Ms. Soledad Herrero, Chief, Child Protection, UNICEF India Country Office, who has kindly joined us through virtual mode, respected resource persons of this regional consultation, and all the esteemed participants of today's program for the regional consultation on juvenile justice. May I humbly request His Lordship, Honorable Shri Justice S. Ravindra Bhat, Judge, Supreme Court of India, to kindly adorn the dais, and I request the esteemed Registrar General, High Court of Orissa, to kindly conduct His Lordships to the dais. Thank you, my lord. May I now humbly request Dr. Justice S. Muralidhar, the Honorable Chief Justice, High Court of Orissa, to kindly adorn the dais, and I request the esteemed Registrar Judicial, High Court of Orissa, to kindly conduct his lordship to the dais. Thank you, my lord. May I now request Honorable Shri Justice Debabrata Das, Honorable Shri Justice A.K. Mahapatra, Shri Bhaskar Sharma, and Dr. Monica Nielsen to kindly adorn the dais, and I request the esteemed Director, Odisha Judicial Academy, to kindly conduct the honorable dignitaries to the dais. May I now seek the permission of our chief guest, Honorable Shri Justice S. Ravindra Bhat, Judge, Supreme Court of India, and Chairperson, Juvenile Justice Committee, Supreme Court of India, to kindly declare the event as open. The event is declared open. As a mark of our heartfelt gratitude, may I now request Judicial Officer Sudeepa Patra to kindly present a bouquet to His Lordship, Honorable Shri Justice S. Ravindra Bhat, Judge, Supreme Court of India, and Chairperson, Juvenile Justice Committee, Supreme Court of India. Thank you. May I now request Judicial Officer Alkananda Mohanty to kindly present the bouquet to Dr. Justice S. Muralidhar, the Honorable Chief Justice, High Court of Orissa. Thank you. May I now request Judicial Officer Baishali Nayak to kindly present the bouquet to His Lordship, Honorable Shri Justice Debabrata Dash, Judge, High Court of Orissa, and Chairperson, Juvenile Justice Committee, High Court of Orissa. Thank you. May I now request Judicial Officer Suchitra Paramguru to kindly present the bouquet to His Lordship, Honorable Shri Justice A.K. Mahapatra, Judge, High Court of Orissa, and Member, Juvenile Justice Committee, High Court of Orissa. Thank you. May I now request Judicial Officer Chinmay Rath to kindly present the bouquet to Shri Bhaskar Sharma, Commissioner cum Secretary, Department of Women and Child Development, Government of Odisha. Thank you. May I now request Judicial Officer Aparna Mahapatra to kindly present the bouquet to Dr. Monica Nielsen, Chief of Field Office, UNICEF, Odisha. Thank you. Beginning with the inaugural session of this consultation, I request Shri Bhaskar Sharma, Commissioner cum Secretary, Department of Women and Child Development, Government of Odisha, to kindly present the welcome address in this August gathering.
Honorable Justice, Shri S.R. Bhat, Judge, Supreme Court of India, Chairperson, Juvenile Justice Committee, Supreme Court of India, Honorable Chief Justice of Orissa High Court, Shri S.Muralidhar, Honorable Justice, Mr. M.B. Lokur, former Judge, Supreme Court of India, and former Chairperson, Juvenile Justice Committee, Honorable Shri Justice Debabrata Das, Chairperson, Juvenile Justice Committee, High Court of Orissa, Honorable Shri Justice Mr. A.K. Mahapatra, Member, Juvenile Justice Committee, High Court of Orissa, and Dr. Monica Nelson, Chief of Field Office, UNICEF. Honorable Judges present here physically, and also Honorable Judges who are participating through video call, my colleagues here, and ladies and gentlemen. It's an honor, it's a privilege to welcome the August gathering here on this occasion of the consultation on effective implementation of Juvenile Justice Act today in Cuttack. Orissa has, and the country has set up different institutions as a part of state building by now, which allows us to do what we need to do to implement the policies and the act more or less satisfactorily. We have the state commission today, the state commission, and we also have the state adoption resource agency. We have got district child protection units. We have child welfare committees. We have juvenile justice boards, and a child protection committees in blocks and gram panchayats as well. We also have introduced new concepts such as ranking of child care institutions. Some of them will be joining us in a couple of hours' time. We also have introduced learning technologies through audiovisual mode, especially in COVID times. We have done a few more initiatives, but the concern today is what we have not done as yet as a government. I would like to spend a minute or two on that. Worldwide today, about 15% of population are physically disabled. We call them special children. We have not really done enough to identify them. We have not done enough to take care of them. Today in India, we reach out to about 2 to 3% of those children who are physically or intellectually disabled. Adoption agencies, it's extremely difficult to locate caregivers for such children. We don't have enough accommodation. We don't have enough therapists, special educators in the society as a whole, and in particular in our child care institutions. We have several other issues I would not like to mention at this stage. As the deliberation progresses, probably will come to that. I would really imagine in due course of time today, we will address many more issues and find solutions to it. Thank you so much.
Thank you, sir, for the warm and heartfelt welcome extended. May I now request His Lordship, Honorable Shri Justice Madan B. Lokur, former Judge, Supreme Court of India, and former Chairperson, Juvenile Justice Committee, Supreme Court of India, to kindly address the august gathering.
Thank you, and good morning, Honorable Justice Ravindra Bhat, Honorable Chief Justice Dr. Muralidhar, Justice Devabrata Das, Justice A.K. Mahapatra, all the learned judges of the Orissa High Court, and the judges participating from the High Court of Calcutta, Patna, Jharkhand, and Chhattisgarh. Mr. Bhaskar Sharma, Secretary of the Women and Child Development of the Government of Orissa, Dr. Nielsen, officers and officials of the UNICEF, Women and Child Development and Government of Orissa, and all the distinguished participants. It's really nice that this program has been organized on the effective implementation of the Juvenile Justice Act. And the focus, as Mr. Bhaskar Sharma said, is not really on what has been done, but what remains to be done. I think that that's a very important point that has been raised by Mr. Sharma. There are 2 or 3 things in this context that I would like to mention. Firstly, about legal assistance. You know, the experience has been that the legal assistance that is being given to children who are in conflict with law is really not adequate. In fact, the DCPCR, the Delhi Commission for the Protection of Child Rights, has conducted a study, which we will be reviewing in a few days' time, on the nature of the legal assistance that is being provided to children who are in conflict with law. And I'm afraid the preliminary indications are that it is rather unsatisfactory, in the sense that the legal aid lawyers meet the children, if at all, you know, just on the date of hearing, and they appear on behalf of the children without really knowing what the case is about, without interacting with the child, without interacting with the parents or the guardians of the child. And, you know, the kind of assistance that is being given leaves a lot to be desired. But these, like I said, are preliminary findings. It gets worse. actually when you're dealing with issues of POXO, where the children are victims of sexual abuse. The result of all this is that children are really treated as spectators to the proceedings. They're not given adequate time to meet with their family. Adult prisoners are permitted time to spend with their family, but children are somehow or the other neglected in this regard. And what we call as mulaqat, or a meeting, which I think is very, very important, particularly for children who are in the observation homes, is not taken seriously and is not frequent enough. So really, the children just become somebody who's a part of the process. We also have issues of failure to apply the provisions of the CRPC. Now, when it comes to actually conducting the inquiry, it is being done in the manner in which it is prescribed by law. But there are other provisions of law which are not being given effect to. For example, Section 436A of the CRPC, it says that if an accused person has spent 50% or half the time of the maximum sentence in custody, then that person is entitled to be released on a bond. This is not applied to children. At least that is the experience that I've had over the last couple of years. And children are there even for all kinds of offenses well beyond that 50% limit. So really, it's a responsibility, I think, not only of the legal aid lawyers or the lawyers who are assisting the children, but also of the juvenile justice boards, which must realize that it's not that some portions of the CRPC are applicable, but that all portions of the CRPC are applicable. The juvenile justice boards must also realize that many of these children, if not all of them, are also children who are in need of care and protection. And that is perhaps one of the reasons why they are there in the observation home. So really a broad view has to be taken by the juvenile justice boards and also by the legal aid authorities. Finally, on this issue, again, there's a problem of the production of the child before the Juvenile Justice Board. Maybe about 6 or 7 years ago, there used to be only 2 observation homes in Orissa. One of them was in Rourkela, and the other one, I'm not sure in which district it was. But I'm glad that today we have 16 observation homes, but yet there are 30 districts in Orissa. And one of the requirements of the Act is that every district must have an observation home. So really, if I may say so, there is a shortfall in this regard. And the conditions in the observation homes may not necessarily be ideal. We've had an instance fairly recently in November last year of children running away from the observation home in Behrampur. One of the reasons why this happens is because of inadequate supervision, inadequate facilities. The children are not looked after properly in terms of education, in terms of hygiene, in terms of nutrition, a variety of reasons. And the best thing that the children think of at that point of time is how to run away. So we've had this, and apparently this is not the first time that this has happened in Behrampur. It has happened earlier also. So really, this is an area that needs to be looked after. How do you deal with children in the observation homes, and how do you deal with the observation homes themselves, provide the facilities? The second point that I would like to make is that of rehabilitation of children. What happens is normally that once the case is over, or once the child has been granted bail, the child is forgotten. But that's not enough. You've had problems of education thanks to COVID. You had problems of rehabilitation in several other aspects. Recently, I had occasion to visit the place of safety where children who are convicted of a crime are kept. And there is an NGO which was doing excellent work in that place of safety. I spent about 2 or 3 hours with the children over there. They performed, played games, sang songs. It was really an exciting moment, not only for me to have to interact with so many of these children for such a long time, but also for the children to be able to participate freely in activities that were organized by the NGO. So I would suggest that it may be a good idea if NGOs across the state are involved in these observation homes. Many of them across the country are doing excellent work, so that children become a part of society. The whole purpose of the Juvenile Justice Act is not only restoration but rehabilitation and reintegration. Once these children go into an observation home or into a place of safety, they feel secluded. That's the impression that I have been getting for a long time, and that's the impression that I got 3 weeks ago also, that they feel isolated from society. So the idea really is to get them out of that feeling of isolation and tell them that they are still members of society and they're still welcome in society, even though they may have been accused of a crime or convicted of an offense. So really, while the state government, of course, and UNICEF, of course, can do a lot in this regard, I think we need to get NGOs also involved in these areas. These two things I would request that if UNICEF and the High Court as well as the state government could look into it, it would be a good idea towards the rehabilitation and reintegration of children. We have to realize that overcrowding is a problem. And that was perhaps one of the reasons why these children from Behrampur wanted to escape. So really the atmosphere in many of these homes is not conducive. And there is a responsibility on the juvenile justice boards also to visit these homes, whether they are observation homes or whether they are places of safety, to ensure that children over there live a life of dignity. They are entitled to that, and there is absolutely no reason why we should deny them that basic dignity. With these few words, I would like to thank all of you and to congratulate the state government, the High Court of Orissa, as well as UNICEF for organizing this conference with the participation of judges from different states as well. I think it's very, very important, and we should not lose the momentum that will be generated by this conference. Thank you very much.
Insightful experiences and highlighting the issues relating to juvenile justice in India. May I now request His Lordship, Honorable Shri Justice Debabrata Das, Judge, High Court of Orissa, and Chairperson, Juvenile Justice Committee, High Court of Orissa, to kindly present the introductory address in this gathering.
Honorable Mr. Justice Ravindra Bhat, Judge, Supreme Court of India and Chairperson, Juvenile Justice Committee, Supreme Court of India. Honorable Dr. Justice S.Muralidhar, our Chief Justice. Honorable Mr. Justice Madan B. Lokur, former Judge, Supreme Court of India and former Chairperson of the Juvenile Justice Committee, Supreme Court of India. Dear brother, Justice Shri S.K. Sahu, Justice Shri Kumari Savitri Ratha, and Justice A.K. Mahapatra, Judge of the High Court of Odisha, and members of the Juvenile Justice Committee, High Court of Odisha. Respected brother Shri Tandon, Judge, Calcutta High Court and Chairperson of the Committee, Juvenile Justice Committee. Respected brother Shri Dr. Eston Pathak, respected brother Shri Ashutosh Kumar, who are the judge from Jharkhand High Court and Bihar, Patna High Court.
and also the chairperson of the respective committees, Justice Parthapratim Sahu, Judge Chhattisgarh High Court, and the chairperson of Chhattisgarh Juvenile Justice Committee, respected brother judges of our High Court, learned Vice Chancellor of the National Law University, Odisha, Mr. Bhaskar Jyoti Sharma, Commissioner cum Secretary, Women and Child Development Department, Government of Odisha, Soledad Herrero, Chief of Child Protection, UNICEF India, the Registrar General, Dr. Monica Nelson, Chief of Field Office, UNICEF Odisha, Director and Judicial of the Judicial Academy, Member Secretary, State Legal Services Authority, and all their members of print and electronic media, distinguished guests, ladies and gentlemen. Namaskar and warm greetings to one and all present in this august house. It gives me immense pleasure in welcoming you all to this millennium city of Cuttack on the eve of regional consultation on effective implementation of the provisions of Juvenile Justice Care and Protection Act 2015, as it stands today with latest amendment which has been made by the Amendment Act of 2021. I would begin by quoting what Nelson Mandela once said, and I quote, "There can be no keener revelation of society's soul than the way in which it treats its children," unquote. Today's child is tomorrow's future. The aim and objective of this consultation is to secure a dignified life and future for the budding children who are required to be groomed for advancement of humanity along with prosperity. Article 15E, 39E, 39F, 45 and 47 of our Constitution confer powers and impose duties on the state to ensure that all the needs of the children are met and their basic human rights are fully protected. The Convention on the Rights of the Child, adopted by the General Assembly of United Nations, prescribes a set of standards to be adhered to by all states in securing the best interest of the child, which is the paramount consideration in every matter concerning them. In fact, we all have gathered here in this magnificent auditorium of this Judicial Academy to deliberate on issues and challenges that the children in India are facing as children in conflict with law or children in need of care and protection. In the coming 1.5 days of this regional consultation, I hope we'll be coming out with some solutions to the problems which we are facing today. And what Honorable Justice Lokur said, that we'll be coming out with the solution, with the things which are required to be done more in future days to come, not what we have done or discuss what we have done. I would like to emphasize the need of the hour that urges for a wider outlook which must go beyond the conventional boundaries in achieving the goal of ending all forms of abuse, exploitation, and neglect of the children. In the last 2 years, the pandemic has forced and compelled the children in India to compromise with their development in all fronts. It's no doubt true that all such required laws and rules are in place in our country for the development of the children. But only when there is effective implementation of those, we can say that there has been real achieved advancement in the direction. The Act of 2015 with latest amendment as it stands today is definitely a beautiful piece of legislation which aims not only dealing with the CICL but also caters to the requirement of the child in need of care and protection, who in any way a vulnerable and helpless child, and it is the responsibility of every citizen of this country to protect the childhood of every child. Proper implementation of the Act through the rules needs thereunder is possible only when all stakeholders work together in tandem and with full cooperation. There must be prompt identification of the issues involving the right of children at every level. I must tell that delay in such matters definitely defeats the very purpose. So in every step, the time has to be adhered to. And otherwise we do that. If we do not do that, ultimately will be failing in our duty, and that will lead to non-achievement of the purpose for which the provision of the act has been made. Many children has become orphaned, and many of them have lost their parents, or either of the parents, or it is in turn our duty to such children, foster such children within the framework and with the aid of the provisions of the act and rules. Child Welfare Committee must have the vision to how to protect, support such children in their education and social fronts. According to the data uploaded on Bal Suraj portal by the state government and union territories, as on 30/3/2022, 10,793 children have lost both parents. 1,51,322 have lost at least either of the parents. 410 children are found abandoned. But the social investigation reports in respect of the majority of such children have not yet been finalized. Further, 19,825 letters have been written by the NCPCR to various district authorities for linking the child and his or her family members to various schemes. Since normalcy by now has been restored, it is the duty of the district of the authorities and all those with the district child protection units to ensure education for the children who have lost their parents in providing all other aids and assistance. Among other issues, the drug abuse and sexual exploitation of the children, as also the child trafficking are measures which need to be addressed on priority basis. A nation which doesn't care to invest on children cannot grow. It's no doubt true that governments, including our state government, are providing financial help to orphan children who have become orphaned in pandemic. But that by itself is not enough unless proper care and planning for the development of such children are made. And most importantly, those are monitored and tracked. It is therefore imperative to have trained counselors, tutors, psychologists, and social workers. All those in need charge of children or observation home, housing the children in need of care and protection must take the assistance of all those people and handle the CICL and CNCP to secure a better future for such children. It's very important that special juvenile police unit must deal in children will conflict with law in a very sensitive way while conducting the investigation with all such mindset and attitude as needed to be shown to the children, keeping in view their future advancement. Committed as well as spirited police officers with special zeal in the direction may be considered to be posted in such places who can make big difference either in case of CICL or even in case of CNCP. The investigating agency must rise to the occasion by specially understanding the problem of the children. All the stakeholders must be abreast with the knowledge of law and rules relating to children and different beneficial schemes floated by the government, which should be brought to their notice. Unless the children are extended with their entitlements under those beneficial schemes, and it serves the real purpose for which it has been meant, that is again will be a failure. In the in the process of bringing them to the mainstream, and there will be no practically there will be no meaning to those schemes. Child Welfare Committee and Juvenile Justice Boards are the pivotal pillars under the Act. It's always required by the officers or persons in those two institutions to keep in mind the constitutional goal and the aim and objective of the Act and accordingly to go ahead. The Act also provides for reformative services meant to provide children in conflict with law for their education, skill development, counseling, behavior modification, therapy, psychiatric support, and other developmental activities as would be necessary and brought out in social investigation reports. At the same time, they too have the duty to inform the District Legal Services Authority for providing free legal aid for the purpose with its quality being maintained. The JJ board, while dealing a case of CICL, are required to maintain a case monitoring sheet of every case and every child, which shall be kept on the top of the file and updated from time to time. This is required to be scrupulously followed. These are few aspects which need to be maintained in the inquiry of the CICL so as to provide momentum to the inquiries for early culmination, which has definite significance. In this consultation and platform will definitely be benefited by the deliberation and academic discourse in the technical sessions. And each of us, when go out to our respective workplace, should carry all such positive outcomes as notes to implement the aim and objective of the Act in a proper manner in ensuring a better and secured future for the children of our country. This consultation is a platform where we can share our views, ideas, best practices, so that the monitoring and evaluation system is further strengthened. It's voiced by many that the implementation of all the provisions of the Act in their letter and spirit is extremely difficult. But I will say that the implementation is no doubt challenging rather than difficult. It's evident from the fact that we have already grappled many of such challenges and are marching ahead every day. Time has come to adopt all such flexible approaches and ideas to implement the Act within the four corners of law, and to have such approaches punctuated with care, compassion, understanding, and proper mindset and attitude. We all are thus hopeful that this consultation is going to be a huge success, and I, as the chairperson of the committee, discharging my duty under the able leadership of Honorable Justice Bhat and our Honorable Chief Justice, I'm sure that you all will be immensely empowered and enriched with the knowledge at the end of the event in having the satisfaction and deriving spirit to march ahead for the achievement of the goal set out under the Act in ultimately helping building the nation. At this juncture, I place through the spectrum of history the voice of Abraham Lincoln. A child is a person who is going to carry on what you have started. He is going to sit where you are sitting. And when you are gone, attend to those things you think are important. You may adopt all the policies you please, but how they are carried out depends on him. He is going to move in and take over your churches, schools, institutions, universities, corporations, and whatnot. The fate of humanity is in the hands of these persons. We all must keep it as mantra, and accordingly take the pledge on this day in doing lot more in the future days to come. I once again welcome you all to this regional consultation on this land of Lord Jagannath and wish you all the best. Bande Utkala Janani.
Thank you, Your Lordship, for highlighting the responsibility and importance of care, protection, and development of the youth who are the future of our country. I now request Ms. Soledad Herrero, Chief, Child Protection, UNICEF India Country Office, to share her experiences and reflections in the course of her work. Madam, please.
Many thanks, and please allow me to do and confirm that you can hear me before I proceed.
Yes, Madam, you're clearly visible and audible.
Okay. Honorable Justice Bhat, Chairperson of the Juvenile Justice Committee, Supreme Court, and Honorable Justice Lokur, former judge and chairperson of the Juvenile Justice Committee of the Supreme Court, Honorable Justice Muralidhar, Chief of Justice of High Court of Orissa, Honorable Justice Debabrata Das, Chairperson of the Juvenile Justice Committee, as well as Honorable Justice Mohapatra, member of the Juvenile Justice Committee in Orissa High Court, Sir Bhaskar Sharma, IS Commissioner Cum Secretary, Department of Women and Child Development, Monica G, the Chief of UNICEF Office in Odisha, as well as the other colleagues from UNICEF team that are there, and a special greetings also to the honorable guests from the states of Bihar, Chhattisgarh, Jharkhand, Orissa, and West Bengal, from members of the High Court, as well as dignitaries from the government. First of all, sincere apologies for not being there. It's been really a pity that some of the commitments haven't allowed me to be there. But one of the positive things that COVID has brought us is the opportunity to more easily connect online. So it's a great pleasure to have a few minutes to share a few thoughts from my side. It is really commendable, the very unique partnership, relationship, and focus and commitment that the Supreme Court and the High Courts have on the child protection agenda, and the way in which they are working together hand by hand with the executive, with the Departments of Women and Child Development and other stakeholders to make sure that the rights of the children are realized. We know, and the earlier statements have really stressed the importance, but I just want to highlight the fact that children's rights, as we know in the Convention of the Rights of the Child, are of universal acceptance. And we are proud, all of us, as stakeholders working to realize the rights of the children. We should be very proud of working on the basis of the Convention of the Rights of the Child, which is, as we know, the international human rights instrument with the largest ratifications in the world. And the reasons are very clear, and they were stated before, right? As it was said before, children are the greatest assets of the nation. And it is only by full commitment from the different stakeholders that we will be able to make a difference. I do want to share few reflections on the three areas of deliberation that this consultation is going to be focusing on. So let me start touching briefly the issues of alternative care that, as we know, are a priority area in the Juvenile Justice Act. And I do want to acknowledge the incredible efforts that the government did, particularly in the context of the pandemic, where a lot of schemes, a lot of efforts were put in place to make sure that the children that were rendered orphans, and statistics were provided before. We know that nationally it was around 150,000 children that were rendered orphans. And it is also very positive to see in the new Mission Vatsalya guidelines a lot of impetus and emphasis on this area. However, and as Justice Lokur said, it is important that we focus on the areas that still need emphasis and impetus to make, for the last mile to be achieved. We know very well that family is the natural unity of society. And the Convention on the Rights of the Child and the Juvenile Justice Act says very clearly that institutionalization should be the measure of last resort. There is a lot of evidence available that indicates and stipulates very clearly the damages of the institutionalization. And it's not a matter of the conditions of the childcare institutions. It's a matter of the need and the role that family community connections play in the life, in the development of a child. I think there is a lot of lessons learned of the COVID response, and also thanks to the action of the Supreme Court and High Courts, there was a large number of children that were deinstitutionalized. So I think it showed that more emphasis on family-based care, on foster care, on kinship care, and very importantly, on preventing of family separation, it is possible. Now, this requires investments, this requires political commitment, and this requires also a very nuanced programs that can help foster care families, kinship care families, to really take care of these vulnerable children. There are a number of states that have taken very bold steps towards having longer-term, multi-year plans that are gonna be setting targets for the institutionalization of children. And I think if we look at the areas that we need to put emphasis on, again, I hope that this consultation will, and the states that are today present, will look into establishing models to put more emphasis and give more children that are coming from difficult situations to given a chance to grow in family environments. I do want to praise as well We cannot do this without the children. And I do want to praise for having brought for the consultation the voices of children that will be talking about the alternative care and their experiences in the alternative care system. Now, the issue of deinstitutionalization or institutionalization of a measure of last resort applies both to children in need of care and protection and also to children in conflict with the law. And here I want to bring a similar reflection, which is the importance of making sure that detention remains as a measure of last resort and only when it's really commensurate with the action that the child is perpetrated. I think Justice Lokur already mentioned that sometimes wrongly interpreted, children end up in observation homes because of their vulnerability factors. And unfortunately, sometimes the law enforcement, justice sector ends up thinking that perhaps observation and institutionalization, it is the right way to go for these children because of their vulnerable conditions. I think it is important to understand that children in need of care and protection and children offenders, children in conflict with the law, are two systems. And even when it comes to the children in conflict with the law, still restoration, reintegration, and rehabilitation should be the desired outcomes. We cannot forget that it still has a punitive aspect. And if a child is provided a detention or an imprisonment, it needs to be founded as well and commensurate to the dimension of the offense. The last point that I want to just briefly touch on is the issues of mental health. I think there's been the COVID pandemic has really offered an opportunity to have and have much more attention and to bring to the public eye the silent pandemic that mental health problems represent globally as well as in the country. We all have been concerned about the increased number of children that have committed suicide in the context of the pandemic because of lack of education opportunities, because of stress, because of the economic pressures, and many children also have fallen into situations of child labor or child marriage, as we know. This is not something new, and this is not something that COVID has created on its own. Global statistics indicate that probably 1 out of 4 people have mental health conditions, and that the large majority will start to be developed before the age of 14. Around 80 to 90% of these will never seek treatment. In India, there are studies that talk about at least 50 million children with mental health problems. We know that there is a lot of interconnections between the justice system, between the child protection and the mental health. And the importance of connecting these 3 services is extremely critical. Whenever a child is an offender, whenever a child is in need of care and protection, the chances of that child requiring counseling and psychosocial support are very, very high. The chances as well of the family and the family environment from where this child comes from needing not only, of course, social protection schemes, which are extremely relevant, but also some psychosocial support, some accompaniment, some counseling is very, very high. So I really want to acknowledge the Supreme Court and High Court efforts alongside with the governments to put in attention on this area. With these reflections, I conclude. But before I do that, I do want to acknowledge and appreciate the Odisha High Court and government in leading this regional consultation. I think it's critically important that we continue to nurture cross-learning, cross-fertilization, and also have supra commitments that can allow us to keep us on check. I think it's very important, and I look forward for this consultation to landing into actionable, measurable priority areas that we can really take forward based on these reflections. From the UNICEF side, I just want to reiterate our commitment to taking this agenda forward. And once again, it is an incredible privilege for UNICEF to work with with the wide range of stakeholders that are today present, that has shown this level of commitment to give, especially children that come from different difficult backgrounds, children that come from marginalized communities, to give them a chance in life. Thank you.
Thank you, Madam, for sharing your reflections and highlighting the importance of cooperation, coordination, and commitment of the various stakeholders for the care and development of the youth in conflict with the law. I now request Dr. Monica Nielsen, Chief of Field Office, UNICEF Odisha, to kindly address the August gathering. Madam, please.
Samastungu Namaskar and a very warm welcome to honorable dignitaries, Honorable Shri Justice Ravindra Bhat, Honorable Shri Justice Madan Lokur, Honorable Shri Justice Dr. Muralidhar, Honorable Shri Justice Debabrat Dash, Honorable Shri Justice A.K. Mahapatra, Shri Bhaskar Sharma, Commissioner cum Secretary, Department of Women and Child Development, Government of Orissa, judges and guests from other states, friends, and UNICEF team. Welcome. At the outset, I would like to echo what Sole was just saying and really appreciate all the stakeholders gathered here today for this consultation, which is coming in the right time, not only because of the COVID, but also in the light of Juvenile Justice Act amendment. UNICEF has been and will continue to support the government of Orissa in ensuring the rights of both children in need of care and protection and those in conflict with the law. The state government, as we have also heard this morning, has been proactively working towards ensuring the rights of children with focus on family-based alternative care for children. Ashirbat scheme for the children who lost parental care during COVID is a perfect example of the government's strong commitment to this end, and there are many other examples. However, as we have also heard this morning, there is a lot and a long way to go yet. There is a lot to do to achieve and fulfill the special requirements of children in institutions. As we have also heard, UNICEF's approach toward juvenile justice identifies institutions as the last resort for children. With UNICEF's primary focus on prevention and converging the efforts of all stakeholders towards strengthening the community-based safety nets for children by engaging with the community structures and platforms for and with children and adolescents, developing the capacity of functionaries to sensitively communicate and address children's needs, generating evidence for state-level advocacy with key decision makers have been some of the key priorities of our engagement. It is imperative that we all ask ourselves and we seek creating opportunities for alternative to the detention of children, promoting diversion and family-based alternative care, focus on family strengthening through linkages to services like sponsorship, foster care, and relevant social protection schemes have undoubtedly accelerated achieving results for children. And one of the ideas that was brought up today by Justice Lokur, engaging CSO and other partners in creating those opportunities. As we have also heard, and we know that there is no dearth of legislations and schemes in the states and in the country. Experience sharing by different states present here today and tomorrow as to how effectively and innovatively the schemes and different programs get implemented is what we expect to learn from each other here. In all child-related legislations, the thrust is essentially on creating child-friendly atmosphere, which largely revolves around the behavioral aspects of the various stakeholders. As we know, in most cases, the child's voice is lost in the adult courtroom or in the insensitivity of the people around. Child-friendly police stations and courts are being set up across the country, and its effectiveness needs to be assessed soon. Also, unpacking and understanding really the situation of children in conflict with law is needed. And while I do not have the numbers with me, but I am sure that together we can work on improving lives of many children by expediting those cases which are lingering there. The idea of restorative justice is also pertinent as this juncture. All over the world, the introduction and implementation of heavy penal measures has not really reduced atrocities. While the offenders are to be made responsible for their offenses, they must be a part of the reformation process. Only then can the objective of rehabilitation be achieved. This particularly holds true for children and adolescents, those in conflict with law, who must be rehabilitated and reintegrated effectively to control those cases, enable them to grow up as responsible citizens. I thank you all for joining us today here. And once again, thank you so much for all the efforts that the government of Odisha has been doing so far. Thank you so much.
Thank you, Madam, for your valuable insights in the field of juvenile justice, the effect of the COVID-19 pandemic on the children of our country, and the need of effective implementation of the schemes already in place for the improvement of lives of youth in conflict with the law. I now humbly request Dr. Justice S. Muralidhar, the Honorable Chief Justice, High Court of Orissa, to kindly address the honored guests and the participants in the inaugural session.
A very warm good morning to everyone. Justice Ravindra Bhat, Judge Supreme Court of India and Chairperson of the Juvenile Justice Committee of the Supreme Court of India, the distinguished guests on the dais, my colleagues who are present on the dais in the auditorium and online, Ms. Herrero, Dr. Nielsen, Mr. Sharma, the Commissioner cum Secretary, Department of Women and Child Development, Government of Odisha, the Advocate General who's present here, the resource persons of the various sessions who are present here, and our very distinguished guests, Justice Harish Tandon from the Calcutta High Court, Justice Cuttack from the Jharkhand High Court, Justice Ashutosh from Patna High Court, and Justice Sahu from the Chhattisgarh High Court. For the Orissa High Court, this is a very important event that we've been able to, in collaboration with the government and the UNICEF, organize this Eastern regional consultation on the effective implementation of the Juvenile Justice Act. I know we're running behind time on the inaugural session, and I'm very keen to hear Justice Bhat myself. So I'll try and keep my comments very brief. One thought I would wish to leave all of you with, even before you begin your deliberations, is how do we get to listen to the voices of children? How do we, in this entire auditorium, we're going to be talking about children in this entire day and 1.5 days. But how much are the voices of the children being heard? I know the civil society groups working with children are going to be representing their voices in these consultations. It's very important for us to remember that when we talk of children, we're talking of a very large group of different ages, different genders, and grappling with life at different stages. And the law tends to homogenize this entire lot as if they have to be treated in the similar fashion. So even when we talk of places of safety, observation homes, the biggest challenge, one of the biggest challenges facing all the institutions and the authorities is that we have a very diverse group of children and we're trying to deal with all of them together. And that itself poses a huge problem. So these sessions that we have been structured, I find, in a manner that facilitates discussions on these complex issues. And we have some excellent resource persons, of course, Professor Ved Kumari, Professor Inakshi Ganguly. These are all veterans in the field of juvenile justice Care and Protection Act. They've seen how the law has changed. They've been important players in this entire arena. And they have first-hand experience of dealing with children themselves in institutions. Then we have Dr. Harish Sethi, the psychiatrist from the Symbiosis Law School, Pune, and Dr. Anindita Pujari, advocate Supreme Court of India. I think they'll bring with themselves the rich experience of working on issues concerning children. Apart from the issue of listening to children, we also have amongst the children population, child activists. I'm sure India has its own versions of Malala, of Greta Thunberg, and it's only that we have not tapped their potential, I feel. At least in this arena of discussions of Juvenile Justice Act, I think we must encourage children's voices and find out how they would like to be treated. And we have a tendency in law to treat all kinds of behavior in a similar fashion. So as a result, what happens is real criminal behavior gets equated with different and non-conforming behavior. So a rebellious child, a child who's experimenting, a child who's adventurous, a child who's experimenting with romance, all of this gets treated as a crime under the law. And it's important from the collective experience of this audience, of this distinguished gathering, to see how we can separate out so that the act serves the purpose it is meant for and doesn't become a tool for oppression. And the observation homes that we have, how should they be structured? How should they be made to serve the purpose of actually rehabilitating the child, integrating the child? Or if the present structure does not enable it, then how can we change those structures? I think we should not be afraid to ask for changes. We need not talk within the existing dimensions that we've created through the law. We must see whether we can change those structures to make it more child-friendly, to make it more purposeful and meaningful for the child. And we're looking at street children, we're looking at children in conflict with the law, children in need of care and protection. We're looking at a whole range of children. So I think this is a wonderful opportunity for all of us to put our hearts and heads together and come up with something meaningful for the child. Thank you for this opportunity, and I'm really wishing to hear Justice Bhat now. Thank you.
Thank you, sir, for highlighting the importance of hearing the voices of the children themselves in taking steps for the improvement of their lives. It is my utmost privilege to request His Lordship Honorable Shri Justice S.Ravindra Bhat, Judge, Supreme Court of India, and Chairperson, Juvenile Justice Committee, Supreme Court of India, to kindly address the gathering and deliver the keynote address.
A very good morning to all of you. Justice Dr. Muralidhar, Chief Justice of Orissa High Court, Justice Madan Lokur, Justice Debabrata Dash, Justice Mahapatra of the Orissa High Court, Justice Harish Tandon from Calcutta High Court, Justice Asutosh Kumar from the Patna High Court, Justice Sahu, the Chhattisgarh High Court, Justice Dr. Pathak from the Jharkhand High Court, judges of the Orissa High Court, Dr. Ved Kumari, Vice Chancellor of the Orissa and National Law University, who's a distinguished domain expert and a pioneer with whom I had the privilege of working, I think 3 decades ago, when we were having the earliest Juvenile Justice Act of 1986. Dr. Inakshi Ganguly, Ms. Soledad Hararo, Chief Child Protection Unit of UNICEF, Ms. Monica Nelson, Chief Field Officer, UNICEF Orissa, Advocate General, and distinguished guests, and all those present here, ladies and gentlemen. I extend my gratitude to the High Court of Orissa, the Department of Women and Child Development, Government of Odisha, and UNICEF for coming together and organizing this event, which I'm sure will lead to productive deliberation and engagement, given that such regional consultations allow for context-specific attention and offer a chance to share notes and learn from one another, who are often facing similar challenges across state borders. I'm in fact happy to note that this consultation does not only involve members of the judiciary and government, but has also taken advantage of subject experts, as Dr. Muralidhar said, scholars, mental health professionals, academics, social workers outside the institutional structure, and involved them in this engagement as resource persons. This is a very welcome step, and I hope this continues hereafter. Having had a chance to look through the concept note and the sessions planned for this conference, there are certain issues and questions which I wish to draw attention to, in the sincere hope that they will find place in the deliberations that are to come in the course of this engagement. Before I begin with specific concerns, I just want to flag that often we fall into the trap of seeing implementation of the Juvenile Justice Act within a silo. This is far from the truth. Care and protection of children extends far beyond the express provisions of the law. Take, for instance, the obligation to provide education. The Sustainable Development Goal 4 and its specific target 4C highlights teachers as the key stakeholders accomplishing the goal of the Education 2030 agenda, which is providing equitable quality education for all. Focusing on the development of this human resource, both quantitatively and qualitatively, is without question a pivotal prerequisite for the realization of the right to education, which is now constitutionally guaranteed under Article 21A of the Indian Constitution. The UNESCO State of the Education Report for India 2021 focuses on this aspect and provides incredible insights into how we must build frameworks that focus on capacity building of teachers for the benefit of children. The report states that Chhattisgarh, for example, has a total of 56,274 schools, of which 76% are rural. Further, 95% of the rural schools rely on a single teacher. Bihar, however, with 90% of rural schools, has a vacancy of 56% in them. That is, it requires 222,316 teachers to simply meet its vacancies requirements. Similarly, of the 45,908 schools in Jharkhand, over 14% of them rely on merely one teacher, and there is a 40% vacancy rate overall. Now, while these statistics may not directly be affected by these deliberations, it is important to acknowledge that education and capacity building of teachers has a massive impact on the overall development of children, playing the role in many ways in the implementation of the Juvenile Justice Act, which recognizes the importance of education by weaving it into its provisions. Therefore, I would urge that in these deliberations, at least a beginning is made to recognize the need for education of children who are institutionalized or find their way into these institutions. When it comes to observation homes, or especially the class of children who get into them, children in conflict with law, the challenge is that they are there for a short stay, and the maximum is spelled out by the law. And most often, many of them are there for few months. The question is, what kind of education policies are we envisioning for them, and what kind of continual monitoring is the state ensuring for these children once we get them to some education plan? Is it meaningful? Is it productive? So these are concerns which I think we should directly engage in and somehow reach a point where we can come out with a consensus and a plan. India ratified the UN Convention for the Rights of Child in 1992, and the General Assembly adopted a resolution declaring last year as the International Year for the Elimination of Child Labor. In this regard, the National Human Rights Commission in August 2021 also called for reports from all states and union territories on the action taken to combat child trafficking for labor. The concerns of trafficking, however, are not limited to child labor as sexual human trafficking is alarmingly high in this region, especially West Bengal, Odisha, and Jharkhand. And unfortunately, this is not always due to a complete lack of infrastructure or prioritization. For instance, Odisha is the second highest state with 741 reported victims in human trafficking for the second consecutive year, despite having 25 integrated anti-human trafficking units in the state. And a large proportion of those trafficked are children. As many as 653 persons were trafficked for the purpose of forced labor, accounting for 44.97% of the total victims in this category in India in 2020. Again, I emphasize that which is reported, and these numbers are of those which are reported. Given that this number reflects reported victims, some may say that the presence of the anti-human trafficking units has in fact helped in reporting, but the situation still reflects deep concerns. Jharkhand had 239 cases in 2019 and 301 in 2020. West Bengal reported 262 in 2019 and 71 in 2020, indicating that perhaps COVID impacted reporting. When it comes to trafficking of children, there is a huge mismatch in data. The report for last year indicates that the number of girls trafficked in Orissa were 81, but the NCRB data reflects that over 3,259 girls were missing since 2011. In addition to this alarming statistics, in 2020 itself recorded 2556 missing girl children in the state. I know I have mentioned numerous statistics, but the unspoken peril is that these two are only indicative of the reported cases, and numbers in reality are far grimmer. This certainly points to the scope for considering a specialized legislation dealing with organized crime, such as trafficking, in these states. However, in the meanwhile, a lot can be done within the existing framework. Regardless of NGOs and civil society organizations that have worked and will continue to work toward curbing this menace, our institutional frameworks must make this a priority and through collaboration with such actors, carry out anti-trafficking efforts, including awareness drives, fostering local community safety groups, stringent verification and vetting, among other strategies. The NHRC's standard operating procedure for combating trafficking in India is an extremely comprehensive stepwise guide that should be implemented through robust institutions with child-centric approach as contemplated by the Juvenile Justice Act itself. In addition to the IPC provision, the Child Labor Prohibition and Regulation Act 2016 and POCSO, as well as JJ Act from section 74 to 85, criminalizes specific conduct and acts in this regard, and it must be implemented stringently. When discussing this, however, I urge you not to stop at merely the need for coordination between agencies and instead go a step further. What happens after the final stage of reparation with the family? For instance, often evidence that is tendered by the child of the offense committed by a person engaging in child labor becomes difficult to procure during the trial for the purpose of punishing the accused. Next, is there a follow-up that takes place after repatriation, both with the child and the parents or guardian? Can that be used to assist this practical difficulty that authorities are facing when convicting the accused? It cannot be forgotten that these challenges in anti-trafficking efforts, much like all the other concerns highlighted in the sessions of this event, are further excavated in the circumstances surrounding the pandemic these last 2 years. Coming to POCSO, in terms of POCSO adjudication, West Bengal has 19,649 pending cases, Bihar with 14,089, and Odisha roughly 12,332 cases pending. Statistics indicate that there has been a rapid increase in such offenses this last decade. For instance, from just 87 in 2009 to 1648 in 2019, cases of child sexual abuse in Orissa, Odisha has seen a whooping 1794% increase in the last 10 years as per the latest national data. Of course, I agree with Justice Muralidhar that we need to look and engage with the policymakers, perhaps try to influence lawmakers that the so-called deviant, the homogenized way that the law criminalizes children, tarring everyone, uh, someone indulging in what is traditionally seen as deviant behavior with someone actually involving in criminal activities, and with the same brush we need to take a nuanced look, and we have to keep our efforts at this. So some of these figures may seem exaggerated if you look at those kind of problems, but yet the statistics do point to a problem of a serious magnitude, and therefore I urge high courts and state governments to consider strategies to mitigate pendency without harming the rights of the accused and ensuring a fair trial. Setting up more POXO courts, institutionalizing the use of support persons to bridge the gap between the victim and the state machinery, which in turn helps in evidence collection amongst other strategies, merit discussion. Sexually abused children suffer from various psychological effects that manifest physically, mentally, and emotionally. These reactions or manifestations are further affected by various factors, including age, support of family, the relationship with the accused, societal stigma, among others. They sometimes suffer a loss of self-worth because they hold themselves responsible for the incident, or they may hold the adults in their lives responsible, which in turn results in them becoming withdrawn. Studies have shown that the development of depression, post-traumatic stress disorder, suicidal ideation, and subsequently substance abuse are seen frequently amongst child victims of sexual abuse. Mental health intervention that is trauma informed, gender sensitive, and encourages survivors to move beyond the framework of victimhood is certainly the need of the hour, and its corresponding training and capacity building requires urgent consideration. Now, coming to the issue of institutional homes and the perils of non-institutional care. It goes without saying that juveniles living in correctional homes or observation homes or juvenile centers are at a risk of developmental delay. Environmental factors contributing to this risk are the temporal context, that is how children spend their time, and social context, which is how and when the caregivers interact with juveniles. Studies suggest that caregiver training positively changed the quantity of time that juveniles spent with their caregivers, which is the temporal context, and the quality of time juveniles spent with their caregivers, which is the social context. Thus, caregiver training has the potential to improve the environment in the residential care facilities and can be used as an intervention strategy by occupational therapists, such as concept of child care institutions have gained prominence in recent times. In these circumstances, a standardized curriculum for persons dealing with children encountering the juvenile justice system, which should include educating the personnel about child psychology, different psychological and biological needs of children in need of care and protection, and children in conflict with law, will go a long way. Another important topic of discussion I noticed on the agenda is implementation of the non-institutional care, which I wish to point out is markedly different from the goal of deinstitutionalization. The former I would characterize as beginning from the get-go as non-institutional options, whereas the latter is to remove someone already in institutional care and then place them in non-institutional care. Deinstitutionalization requires the balancing of many concerns, and I must express that I'm cautious about referring to it as a one fit all final solution. Since a child is placed in institutional care as a step of last resort, the act of deinstitutionalization too must be done only as a result of immense scrutiny and qualitative evaluation, which is sure to throw up numerous concerns that require our serious contemplation. So for this discussion, I hope your approach will reflect that the glove may fit for some scenarios or type of cases, but it need not fit for others. And we may need also to consider other long-term alternatives for such situations. One small example I give is a child which is trafficked and institutionalized. Do we send back the child home? Then we have to make a deeper scrutiny. Who trafficked the child? Someone amongst her or his relatives was he or she guilty? Then in such a case, do we send back the child to her home? So these typical concerns surround the debate on deinstitutionalization. Another aspect is how are we supporting children leaving a child care institution. For instance, Section 46 of the Juvenile Justice Act allows for financial support to be provided to children who live on completion of 18 years to facilitate reintegration into the mainstream of society. Is monetary assistance alone adequate? How can we continue to monitor and maintain an avenue to periodically check in on them? So these are concerns I would urge you to take into consideration in your deliberations over the next sessions, in the few sessions that you're going to have over this today and tomorrow. And consideration of all these issues and questions will gain significance, especially in your technical session 2 on legislative changes to the Juvenile Justice Care and Protection of Children Act in the context of amendments. In relation to this, before I conclude, I want to flag that the prerequisite of accurate empirical data cannot be emphasized enough. For instance, look at the state of Odisha, which has around 6 observation homes under Section 47, with 683 children in conflict with the law, placed that works out to about 113 children per observation home. A total of 181 children's homes, that is 175 through NGOs and 6 maintained by the state itself, with 7,083 children, which roughly works out to about 40 children per home. Six special homes under Section 48, with 5 children in conflict with the law, placed, which reflects perhaps a mismatch of requirement infrastructure, or even more gravely, that the infrastructure exists, but is A, not being utilized to place children in conflict with the law, or B, not being modified to fit with other requirements of the state within the juvenile justice system. One place of safety with 69 children placed, and 0 fit facilities as required under Section 51. There is none for temporarily receiving children for specific cases that arises. Are children in these institutional facilities receiving individualized care in a manner that is responsive to the child's needs, background, situations, and levels of maturity? How will this data inform our deliberations on implementation of non-institutional care? These are questions I hope you will consider. In the judgment of the Supreme Court in 2018, that is Sampurna Behura, through a series of interim orders over 12 years and by way of final judgment in 2018, authored by Justice Lokur, the court issued a slew of directions to facilitate the implementation of statutory requirements and improvements for the juvenile justice system in India. One suggestion being biannual audits of the implementation of the Act, which I think would undoubtedly help aid this process of collecting empirical data and in turn assist in further decision making. This is because the common challenge I perceive we are facing pan-India is the need to get a clearer picture of the numerous obstacles and their unique effect on each region. As an example, in the aftermath of the 3 waves of COVID, we have data from experiences and frameworks established over the last 18 odd months that we can reflect on and accordingly course correct or improve upon. Moving from an immediate triage approach, we must firstly look to sustainably continue supporting and monitoring the needs of children already affected by the pandemic. And secondly, using this data, discuss safeguards and measures to put in place that can withstand and mitigate such impact in the future. These are some of the concerns that I hope will feature in your deliberations. I'm at one with Justice Dr. Muralidhar. When he flagged the issue of the voices of children not being heard, the challenge is to ensure that children with their vital stakes and their unmet requirements are assimilated in the discourse. There is a need to equate and provide spaces and for the voices that we have to hear. In other words, a listening point to factor the needs of those who are traditionally not even heard. I would end this address by saying the true equity and justice of a society is how fairly it treats its children and the kind of policies it envisions and evolves to ensure that they become fullest and equal participants as citizens in the nation's journey. I wish you all luck and look forward to the takeaways and actionable agenda that will be born from these efforts. Thank you.
Thank you, Your Lordship, for highlighting the importance of coordinated participation, monitoring, and deliberation by all stakeholders in all-round as well as specific development and education of the youth in conflict with the law. As a token of our respect, humble appreciation, and immense gratitude, we would like to present a memento to our esteemed chief guest of this regional consultation. So I humbly request Dr. Justice S.Muralidhar, the Honorable Chief Justice, High Court of Orissa, to kindly present the memento to His Lordship, Honorable Shri Justice S.Ravindra Bhat, Judge, Supreme Court of India, and Chairperson, Juvenile Justice Committee, Supreme Court of India, to honor his presence in this distinguished gathering. Thank you, Your Lordships. May I now humbly request His Lordship, Honorable Shri Justice A.K. Mahapatra, Judge, High Court of Orissa, and Member, Juvenile Justice Committee, High Court of Orissa, to kindly propose the vote of thanks.
Namaskar and a very good evening, good morning to all, one and all. I'll start with the words of Mahatma Gandhi. If we are quote, if we are reach real peace in this world, and if we to carry on a real war against war, we shall to begin with children, and if they will grow up in their natural innocence, we won't have to struggle, we won't have to pass fruitless idle resolutions, but we shall go from love to love and peace to peace until at last all the concerns of the world are covered with that peace and love for which consciously or unconsciously the whole world is hungering. In the words of Pandit Jawaharlal Nehru, I quote, "Children are like birds in a garden and should be carefully and lovingly nurtured as they are future of nation and the citizens of tomorrow." I feel honored and privileged for having received this opportunity to propose a vote of thanks on this momentous occasion. Today, indeed a great day for all of us, as we have with us Honorable Mr. Justice S. Ravindra Bhat, Judge, Supreme Court of India, and Chairperson of the Juvenile Justice Committee, along with gracious Madam Lalita Mohini Bhat, Justice Madan B. Lokur, former Judge, Supreme Court of India, and Chairperson, Juvenile Justice Committee, Supreme Court of India. On this grand occasion, we feel honored that Honorable Mr. Justice S. Ravindra Bhat acceded to our request to grace the inaugural ceremony of the Regional Consultation on Effective Implementation of Juvenile Justice, Care and Protection of Children Act 2015. The very presence of His Lordship is a reflection of my Lord's dedication, love, and commitment for the betterment of the children. It is my virtuous privilege to convey regards and obligations on behalf of the High Court of Orissa and the people of the state to His Lordship for his on this auspicious occasion and sharing his noble ideas and inspiring words for all the stakeholders for the upliftment of the children. We are greatly encouraged by His Lordship's gracious presence and immensely benefited by His Lordship's inspiring address. We are equally inspired and energized by the presence of Honorable Mr. Justice Madan B. Lokur, former Judge of Supreme Court India, for gracing this inaugural ceremony. His Lordship's generous presence virtually has not only made us very proud, but also His Lordship's charismatic words has infused energy to help those children who are in need of care and protection. I express my heartiest gratitude to His Lordship for sparing valuable time amidst busy and hectic schedule to grace this grand occasion. I extend my hearty gratitude to Honorable Dr. Justice S.Muralidhar, the Chief Justice of High Court of Odisha, without whose vision, constant encouragement, and leadership and commitment to the cause today's program would not have been possible. My Lord, the Chief Justice is a guiding force for all of us in organizing this regional consultation. I take this opportunity to extend the vote of thanks to Brother Justice Devrat Das, Judge High Court of Orissa and the Chairman of Juvenile Justice Committee, High Court of Orissa. We are equally delighted and thankful to Brother Justice Parthapratim Sahu, Justice Harish Tandon, Justice S.N. Pathak, Justice Ashutosh Kumar, Chairpersons of Juvenile Justice Committees of High Courts of Chhattisgarh, Calcutta, Jharkhand, and Patna, respectively. We are equally thankful to sister and brother judges of the High Court of Orissa, present physically and virtually, whose kind and generous presence on this momentous occasion has not only boosted our spirits, but also instilled positive vibes within us. We are also thankful to Shri Ashok Pariya, the Learned Advocate General of the state of Orissa. I also extend my special vote of thanks to Shri Bhaskar Sharma, Commissioner cum Secretary, Women and Child Development Department, Government of Odisha, and Shri Arvind Agarwal, the Director, and his team for extending their cordial and relentless support in making this inaugural ceremony a grand success. I extend my heartfelt gratitude to Soledad Herrero, Chief Child Protection, UNICEF India, Country Office, Dr. Monica Nelson, the Chief of Field Office UNICEF, Ms. Neha Naidu, Child Protection Specialist, and the team of UNICEF for their relentless support in making this inaugural ceremony a grand success. I extend my heartfelt gratitude to the resource persons and the experts whose valuable insights will become immensely beneficial to all. I thank Professor Ved Kumari, Vice Chancellor, National Law University, Odisha, Cuttack, Dr. Mohan Nigudkar, TIS Mumbai, Professor Nakshi Ganguly, Honorary Professor, NLU, Odisha, Cuttack, Dr. Harish Shetty, Psychiatrist, Symbiosis School, Pune, and Dr. Anindita Pujari, AOR, Supreme Court of India, for gracing the occasion. I also extend a vote of thanks to the officers of the Government of Odisha for gracing this occasion to encourage us on this momentous occasion. I extend my vote of thanks to the representatives from the Women and Child Welfare Department, Government of India, and NCPCR for gracing. I extend the vote of thanks to the Registrar General and the members of the Registry, High Court of Orissa. I also extend my vote of thanks to the Director, Odisha Judicial Academy, and its team to make this function possible and making all the arrangements for the guests and the invitees. I extend my vote of thanks to the members of Odisha State Legal Services Authority and his team for their support in organizing this consultation. I extend my vote of thanks to the members of the Secretariat Juvenile Justice Committee, High Court of Orissa, for their untiring efforts to make this occasion a success. I convey my gratitude to the participants, the PMJJBs, the presiding officers of the children courts, the chairpersons of CWCs, representatives from the Special Juvenile Police Unit, DCPOs, superintendents of observation homes, and representatives from civil society organization of all the 5 participating states. I cannot forget to express my thanks and gratitude to all of the dignitaries and guests present here on this grand occasion. Your presence has instilled positive energy in us. I propose the vote of thanks to the members of print and electronic media and all those who have toiled hard to make this function a grand success. Before parting, I extend my gratitude and propose a vote of thanks to all those persons for whose wishes, help, cooperation, support, and participation has made this inaugural function a huge success. It is indeed appreciable that the Juvenile Justice Committee is actively involved in monitoring the juvenile justice institutions and disseminating knowledge through consultation, training programs, and seminars. Also, all the stakeholders in their untiring endeavor, have worked together in preserving, protecting, and promoting the rights of the children during this pandemic situation. Thank you. Bande Utkav Janani. Jai Hind.
Thank you, Your Lordship. I now seek the permission of our honored chief guest to declare this event as closed. The event is declared closed. I now humbly request all the dignitaries on and off the dais, as well as the esteemed participants, to kindly rise for the rendition of the national anthem of India.
गण अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे